You're now going to hear from a bunch of lawyers, and so the tenor, I suspect, will be somewhat different. Let me, before I turn over to the panelists, just say a word of introduction about lawyers and legal methods and how we come to many of these problems. Law tends to prioritize the private. What we call private ordering is the normal state of affairs. We believe that mutually beneficial exchanges between people should take place and that they should be enforced. That's our law of contract. Environmental issues pose a challenge because they raise the question that was raised in the that was mentioned in the last panel of externalities. So we have to move to a world in which private ordering, private mutually advantageous gain cannot control. And so this is a domain where, because there are externalities, because we're dealing with public goods in many instances, the legal approach is to regulate. And regulation takes two forms. Regulation takes the form that lay people tend to associate with legal regulation. That is, you have a government agency, you prescribe a number of commands that have to be followed on an ex ante basis. That is, the legislature and administrative agencies put together a menu of conducts that are expected from those that fall under the sway of the regulation. Lawyers tend to focus as much on not on the ex ante side of regulation, but on the ex post. And in particular, in the United States, we are a highly litigious society, which means that we conduct a great deal of our regulation through after-the-fact litigation in a way that's supposed to incentivize and internalize socially optimal conduct. But we have a menu across all three domains of private conduct, private ordering, best practices, community norms that operate powerfully in some settings, ex ante regulation, usually done by government directive, that operate well in some settings, and the ex post accountability that is supposed to be a supplement to the first two. So let me give a concrete example that is germane to the topic today. The Volkswagen emissions scandal. So Volkswagen is a company with a strong internal culture. It has internal norms. It has internal gatekeepers in the forms of lawyers and executives and boards of directors, two boards of directors in the German context. And it is supposed to have certain forms of compliance with socially desirable conduct and requirements. Volkswagen also is subject to ex ante regulation. It was told if you are to sell diesel engines, they must have a certain measure of environmental compliance, or they may not be marketed, not just in the United States, but in Europe and increasingly in other parts of the world as well. And third, they face litigation risk in some places. And realistically, the only place they face litigation risk is in the United States. So I had a colleague, the dean of the Saragossa Law School from Spain, come spend some time at NYU. The Spanish Bar Association gave him money to study collective redress and what can be done in the environmental context. And he came away saying that Volkswagen is, in itself, a perfect example of legal regulatory systems that work and don't work. In the United States, Volkswagen spent $20 billion on remediation. It had to get dirty cars off the road. It had to pay for all the people who had purchased these diesel cars to at least have the option, and over 90% took it, of buying a new car. In Europe, where the bulk of these cars are concentrated, there has been no legal redress whatsoever. There is hand-wringing. There is a proposal in Germany that if you join a consumer alliance, it can stand in for you. It can perhaps sue, but it cannot collect damages. It cannot get an injunction. It can just get a declaration that this was done badly, which is a little like kicking in an open door at this particular point. In Brazil, Volkswagen was a disaster because Sao Paulo was on the verge of changing its entire system of its municipal fleet. Garbage trucks, ambulances, buses, cabs. And Volkswagen persuaded them that the clean diesel was the fuel of tomorrow, not natural gas, which Buenos Aires went to. I'm Argentine. Antonio has the misfortune of being Brazilian.
Brotherhood.
And so they locked in Brazil for a generation, because Sao Paulo can't just replace its entire fleet. So it's an entire generation of destruction. And so we have these questions about how do you get the norms? How do you get the regulations that are compliant to the socially desirable objectives, and you get what's the stick at the back of this. So Katie's going to start more on the norms side. Justice Benjamin, who was a crusading prosecutor in his day and is now a semi-retired into being a justice of the High Court of Brazil, and he's going to talk about the judicial side of this, and that's where we're going to go.
So I'll start out with some thank yous to Melissa and Nancy for having me. I realized I had not even ever looked at the American Association of Law Schools Statement of Good Practices before coming here today, so at minimum, you've made me a better law professor, and as long as I'm giving thank yous, Patrick Kinney, thank you for doing research that undergirded the endangerment finding. Very important to us attorneys. So I'll note there that we're followed by a separate panel on academia. So I'm going to try to reach out and discuss law in different capacities, but I would be remiss if I didn't tell you I am a law professor. So that is the perspective that I come from. And I think in terms of thinking about intersections between the legal professionals' climate knowledge, climate advocacy, and professional responsibilities, there are some pretty easy cases, and there are also some harder cases. And I'll talk to you about why I think, for the most part, what the easy cases are, and then highlight three areas where I think there's a little bit of muddle and some harder questions. In terms of why, to give a sense of, climate advocacy is a pretty comfortable fit for environmental law professors. So when you do go back to those AALS statement of good practices, they explicitly say that because legal academics, we are freed from serving client interests, we actually have a special responsibility to pursue individual and social justice and to seek law reform and advocate for improvements in the law. So it's kind of a core part of what we do. In terms of the kind of work that I do as a legal academic related to climate change, a lot of it's already been touched on. It's participating in amicus briefs, publishing papers, speaking at conferences. I'm also a campus representative for the Climate Science Legal Defense Fund, a group that provides pro bono representation to climate scientists, and part of that is talking to scientists on campus about how to respond to harassing FOIA requests and congressional subpoenas and the like. So engaging in climate advocacy is a pretty easy fit or case for law professors. It's also, I think, a pretty easy case from a pro bono perspective for practicing attorneys. So if you look at the model rules of professional conduct, attorneys are encouraged or should aspire to do at least 50 hours of pro bono legal service a year, while the core of that is meant to be service to low-income persons of limited means, which you might fit climate adaptation for environmental justice communities into that. The model rules also recognize the value of participation in activities for improving the law, so law reform efforts. In terms of advising clients, the model rules at least say it's permissible, although they don't say you have to or should, but they say it's permissible for attorneys advising clients to advise them about moral, economic, social, and political factors relating to their business, so the door is open to that. And that there have now been two national conferences, the National Conference of Lawyers committed to addressing the climate emergency that brings lawyers together from all different aspects of the professional life of lawyering to try to think about our responsibility and role in addressing the climate solution. And I think in terms of the traditional toolbox of lawyers, I'm pretty confident and that lawyers have really gone to the four corners of our traditional toolkit in terms of climate change. So in terms of the ex-post litigation side, I think enterprising catalyst, lawyers have used catalyst litigation to squeeze just about every single ounce of legal authority they could find in statutes, existing statutes, to try to control climate change, whether it's litigation under the Clean Air Act or seeking to force the consideration of climate impacts under the National Environmental Policy Act, or trying to get species who are climate threatened listed under the Endangered Species Act. I'm pretty comfortable we've done a really great job on that. There's also an enormous amount of really interesting catalyst litigation going on in the common law and constitutional side of things, so cases seeking to bring public nuisance actions or to hold large emitters responsible for climate harms. They're forging some really fascinating and interesting new legal theories at the intersection of constitutional, of public nuisance law. Some interesting theories trying to force government to act, adverting to the public trust doctrine and substantive due process. And lawyers have been really active on the law reform side, being engaged in helping to craft the America's Climate and Energy Security Act, which is probably the closest we've gotten to federal climate legislation. It passed the House. Lawyers deeply engaged in negotiating the Paris Agreement as well. But that's all maybe, that's within the traditional toolkit. Maybe it's part of our malignant normality. As Melissa's book, Eco Republic, suggests, maybe we need something more transformative. So thinking about what are some three kind of harder cases I see with respect to the intersection of climate and the legal profession. One is what I think of as, what do we think about agnostic mitigation and adaptation approaches, or I sometimes think of them as the bait and switch, or so the idea that we try to kind of trick people into action on climate by disguising it as something else because we're worried that they have an ideological reaction to climate. So that's one kind of harder case. The second I just think of as lawyers and corporate climate lies. So the role of lawyers in perpetuating the disinformation campaigns on climate science and whether there's some ethical uneasiness we might have about that. And then the last would be the intersection between lawyers as climate advocates in their professional capacity and their private lives. So walking the walk is what I think about it. Is there some sense in which we have a professional responsibility to reduce our own carbon footprint? So I'll talk a little bit about each of these. First, in terms of the bait and switch or agnostic adaptation and mitigation, what do I mean there? So it's ubiquitous to do this. The idea is, so for example, one of the most successful kind of on-the-ground efforts to get individuals to reduce their energy use was the Kansas Climate and Energy Project. And essentially what they did is they went to 6 small towns. They got them to achieve a 5% reduction in energy use. But the messages they used were purposefully divorced from climate change. They did not use the term. So they focused on creation care, economic development through green jobs and thrift. In their own words, although we believe global warming is the defining challenge of our generation, CEP consciously decided to sequester the climate conversation. We focused instead on finding common ground with people across the state. Similarly, legal scholars, there are a group of legal scholars who have come out and suggested how could we use law to try to promote a norm of carbon neutrality. And what they suggest is that we not ground that norm of carbon neutrality in environmental protection because it's too polarizing and not widely enough accepted, and instead it be grounded in a norm of personal responsibility. With respect to agnostic adaptation, I know we've had some discussion already about farmers being on the front lines. So there are lots of examples of government policy specifically designed to try to get people to adapt to climate change, but without talking about climate change. So if you go on the agroclimate website, which is part of the USDA climate change adaptation strategy, you have to click a lot to find any reference to climate change. So is this kind of bait and switch or agnosticism good or bad, and how does it relate to some responsibility we might have as professionals to bear witness? And in terms of whether it's good or bad, I just run into a lot of, I'm not sure, I don't know, but I can see potential benefits and potential problems that I'll flag. So maybe it's good because we can reach audiences we wouldn't otherwise reach who get turned off by the concept of climate change, so it can increase mitigation efficacy. It can increase the efficacy of our adaptation outreach because we are able to kind of avoid that problem. So there is some evidence. I think there's an article in the Journal of Environmental Psychology that suggests that if you take a group of conservatives and you suggest to them a way to change their watering practices on their farms, and you couch it as an improvement in farm technology, they love it. If you couch it as a climate adaptation technology, they don't really like it. So maybe there is some reason to think that it actually would increase efficacy. I think there's also maybe an argument to be made that it doesn't matter why I get someone to buy a Prius once they have a Prius and they realize, oh, it actually fits better into parking spots, or there are these other co-benefits, and it becomes part of it kind of creates, opens up the possibility, and so then it doesn't really matter why they originally adopted it. I think there are also a lot of concerns, though. So one concern you might raise about agnostic adaptation and mitigation is that it strikes me that it's possible that we're missing a cognitive gateway for people to engage with climate change. So particularly with respect to adaptation, and now I'm a lawyer with a BA in American history citing to social science research. So in terms of paying respect to other fields, but that's what I'm doing. There, some folks have suggested a risk salience hypothesis. So this idea that adaptation, by making climate impacts more salient to people, can increase concern about climate change, which can then increase support for willingness to reduce climate change. There's something that's been raised, the disentanglement principle. So some people say a lot of people don't like the solution, the things you have to do to mitigate climate change because it's hard, or they think it's going to be expensive for them. But adaptation, which is around local communities organizing to protect themselves, is more, people like that idea better and therefore aren't as resistant to accepting climate change in that context. So in that way, you could understand talking about climate change in the context of organizing local communities around adaptation as a way to, a cognitive gateway to encourage acceptance of climate science. Another concern I have is that I just find it a little bit repugnant from the perspective of climate justice that in a society that already has compared to the rest of the world, enhanced capacity to adapt, that we're going to go about protecting ourselves against climate change without recognizing the problem, and what does that do with respect to our sense of responsibility to the rest of the world and funding for international climate adaptation. I think there are also concerns about when we shroud climate policy or make it agnostic, that it can lead to imperfect policy. So mitigation and adaptation are oftentimes closely connected. So you wouldn't want to, for example, adopt an adaptation policy that increased greenhouse gas emissions, right? Or you wouldn't want to adopt a mitigation policy that was maladaptive. So I think there's a potential difficulty there. And then this is when, I think it's always a good sign when you're at a workshop and you keep changing your presentation based on what other people have said. So one thing I'll add that occurred to me is hearing the prior presentations is that I do think we should be mindful of, if we're going to be the experts in the back room trying to sell something and obscure the reasons why we're selling it, of the possibility we could undermine our credibility as experts and professionals. If one of the biggest, I think, pieces of learning we have is that messengers need to be trusted. And I think we are already seeing a rejection throughout the rest of the country that certain words like sustainability are toxic because they are understood to be an umbrella, a code word for lots of other things that come under it. And so I think that's a potential problem with adopting a bait and switch approach. In terms of lawyers and corporate climate lies, so I'm thinking here now about what Naomi's work most notably has revealed in gory and graphic detail, the concerted effort by certain energy interests to sow doubt about climate science in various ways. And in terms of, I think there's some forced order impacts you can see from that. So Gallup, for example, in terms of, has a nice description on its website going through the history of public opinion polling in the US, and they actually, they suggest that certain dips in public opinion are related to flare-ups of disputes about climate science. I think you can certainly, in terms of an impact of that, look at the fact that we feel the need to hide that we're talking about agnostic mitigation and adaptation at all. But and in terms of our lack of political will, right, that's probably a piece of it. But what's more interesting right now in the legal field to me is that there are a whole host of second-order legal ramifications that are flowing from the revelation of this disinformation campaign. So one is, did this disinformation campaign result in violations by those companies of various securities laws or the Martin Act? This is the investigations brought by the attorney generals of New York and other states. I think there's a really fascinating Massachusetts versus EPA, which is a great decision under the Clean Air Act, holding that carbon dioxide is a pollutant under the Clean Air Act. One of the best biopsies of that decision that I've read, typically an agency would have been afforded great deference in that kind of decision, and it wasn't here. And one of the best kind of explanations for that I've seen is that the Supreme Court was really worried about politicization of science at the agency. And even though they didn't come right out and say that, that's maybe why the agency wasn't given a lot of deference to try to say that carbon dioxide couldn't be a pollutant. But another kind of second order legal ramification that this conference made me think about is, well, what was the role of Exxon's in-house legal counsel at the time they were orchestrating this public disinformation campaign? Going back to the model rules of professional conduct, it's hard to see. You can make an argument that maybe there was something improper, but there's certainly not, I don't think it's a strong one, and you'd kind of be pushing the boundaries of ethical norms in the law profession to do that. Lawyers are prohibited from knowingly making false statements of fact to a tribunal, but of course we're not talking here about an adjudication before a court, so that's probably irrelevant. Lawyers are also prohibited from knowingly making false statements of material fact to a third person. I think there's enough wiggle room about what's a material fact and what's knowingly that probably doesn't provide much help. The one that is maybe a little bit intriguing is that there is a general catch-all rule maintaining the integrity of the profession, Rule 8.4 misconduct, that provides that it's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, the so-called dishonesty rule. It might be interesting, and maybe I'll see what kind of reaction I get, to take a spin and go through that and try to see if there's any juice you could get out of that. And after today's conference, maybe I'll be encouraged to do that. Some would argue that that part of what the lawyers kind of involved in orchestrating these campaigns are doing is zealous advocacy on behalf of their clients. So there are going to be some counter arguments there. There may also be some First Amendment concerns about whether we can stop attorneys from doing that. But in some sense, kind of to, contemplating today's discussion with respect to this idea that as experts we need to also know the limits of our knowledge and respect experts in other fields, it's a little bit different for attorneys because we're not really experts in much. What we're really expert at is translating other experts into law and policy and into the courtroom. And in that regard, it does occur to me maybe there is an ethical rule that maybe we should contemplate something that it may be tricky and we might get it wrong, but at minimum, we shouldn't be, when we know it's not true, be able to put it forward. So, and then the last, and I think I'm out of time, but one very quick, should lawyers as professionals walk the walk? Do we have an obligation to take action in our personal lives? And I think that, I certainly think legal climate professionals have an opportunity to be norm entrepreneurs, so to encourage others to take behavior. I also think maybe the more interesting example is that the absence of personal action consistent with your professional belief can undermine your professional credibility in this regard, so I think there's maybe a close connection. And I will say just anecdotally, I do sense that relating to, even in a professional context, to students and at conferences, how decisions I'm making in my personal life reflect my own belief about what's going on in the climate seems to really resonate with people. Like, for example, when environmental law professors get together, we inevitably have a conversation about eco-necrotourism. What dying climate ecosystem are we going to make sure to get our kids to soon before it's gone? Which people seem to, oh my gosh, so you really have to do that. So that's where I'll stop.
Thank you. Tonya?
Yes. Well, thanks first to the organizers. Can you hear me? Yes. Melissa, our hostess here, in fact twice, last night too. And Nancy that invited me. I suspect some had played a role in suggesting my name.
We had to overrule his objections.
Okay, but this was later, I suppose. And also, it was good that Sam said a few words before the two of us spoke, because he gave a very concise introduction on how law operates in areas of complexity like the one we face. I have to say that the biggest surprise when I got this invitation was with the title, Witnessing Professionals. And the question I asked myself, can a judge, instead of taking or getting witness, be a witness through her or his work and practice? So I tried to organize my presentation along those lines, reaching the conclusion precisely on whether we judges, through our work, can play the role to ourselves and to the community, and in this case, not just the local community, but the international community in climate change as a witness. I'm not discussing here the legal, the international, the national, in this country, state, or even local frameworks. I'm not discussing the litigation that we already have, and in some countries quite successful, like in Holland, Pakistan. I will focus on judges and how we perceive or don't perceive the climate change crisis. But perhaps it would be helpful to begin with something that is so obvious that we never mention when we talk about about judges, is that we judges are the adjudicators of life and death, literally. So it's not really the doctor that will sign the final document. Oh man, he is dead or she is dead. If there is litigation when death happen and the implications, this will have to be decided by a judge. The same thing with birth, and I don't want to go into this debate in the United States about birth. And the unborn and so on. Those are issues that at the end of the day are decided by judges. We also decide on things that are quite intangible, like love. It's not just poets that deal with love. Unfortunately, and I say unfortunately, because usually when a love issue comes to us, it's because it has become something else, different. Why am I saying the obvious? Because if we are the final adjudicators of things like life and death, the next question is, do we have a role to play in the climate change debate, which has to do not with life, but with something even more important than life, the foundations of life. So that's the so obvious feature of our profession that I thought it would be helpful in mentioning at the very beginning. One are the challenge that we judges, it's a very brief overview of the challenge that we judges face in dealing with climate change. And 10 years ago, this would be a theoretical question because we didn't have a concrete case before judges. But nowadays, it's not abstract; it's very concrete. And of course, there are more theoretical or general challenge and more specific ones in terms of effectiveness. Pragmatic ones, if you will, of the role that judges can play in climate change. I should say make one very brief observation on how fast the legal system changed in respect to climate. And this is important because we, as judges, are not just adjudicators of life and death, but we are also the keepers of the status quo. And that's why law is usually described, there is some truth in this, as slow to adapt to changes. But in respect to climate change, we have seen a revolution in not just in legal practice more recently, but in the past 25 years in legal theory in respect to climate. When Sam and I went to law school, we are almost the same age. We, in the first year of law school, one of the things that we learned very easily was that there were some goods, veins in life that were outside of the scope of law. And one example, and coming all the way from Roman law, was the atmosphere. And nowadays, we take it for granted. There is no discussion. If here we were in a classroom, there would be no discussion on this fundamental change in the foundation of the legal system. And it's not just the atmosphere that becomes a legal entity. It is something more complex than the atmosphere itself, because it's the climate system with all its synergies and complexity. It's so complex that law doesn't want to define it. So we just mentioned climate change. And we don't say, and those things are implicit in the legal narrative. We don't say we are protecting the climate. We say we are fighting climate change, as opposed to other values that we protect in society, that we say we are protecting this value, and then addressing through law the violations of or attacks to those values. So this is a fundamental change in the pillars themselves of the legal system. The difference now. This morning, one of the speakers, where is she? I can't remember her name, spoke on some unique characteristics of scientists.
I think I said distinctive, but okay.
Oh, no, you? Yeah.
I can't see where this is going.
No, yeah. Well, yes, it was Naomi. She's sitting there. So Naomi and I, during the break, I said, well, I think it's not just scientists, I think judges as well. So what are the unique characteristics of our legal profession? Well, first, and of course, from those features, we can take the challenge that judges face in addressing climate change issues. One is that law, and we judges, are used and we are trained to address situations in which we clearly have a perpetrator and a victim. So this is a fundamental paradigm in law. It's adversarial precisely because you usually have those. But here in respect to climate, you have something that we don't say this often, but it's true. We are victims, but at the same time we are perpetrators. So this confusion of roles and positions create problems for a judge. Because at the end of the day, how can a judge be completely independent if the judge himself is part of the problem? Second, we work traditionally with a very rigid scheme of rights and duties. And in the climate change context, because of the fragmentation, synergies of action and consequences, this is very difficult. Duties are confused with rights. Third, judges are bound, are limited by jurisdictional boundaries. And I will not even touch the surface of this topic because Sam has written extensively, including books on collective access to justice and issues related to those boundaries. But I would like just to stress one or two points that are directly related to climate change. First, that we make a separation, and this is valid for everything, between national and international jurisdiction. And climate change doesn't fit precisely within those two categories. We also, as judges, we are trained to deal with cases in which the parties, that's the great majority of cases that any judge in the world gets, the parties, not just one party, but the parties are in the same jurisdiction. We developed creative a number of techniques in order to deal with those problems, but that's I can tell you as a judge, it doesn't matter if you are in China, in the United States, or in Brazil, the great majority of cases, the parties are there within the jurisdiction. Well, this is quite problematic in the climate change arena because the parties are everywhere. It's not that the parties are just in another jurisdiction. The parties are everywhere, the victims are everywhere, and the sources of the disputes are everywhere. What we, and this is my conclusion to this brief presentation of the uniqueness of the way judges operate, not just scientists, but judges, is that in fact what we are looking for, without saying, and we cannot say, especially in this country, is judges that in doing what they're supposed to do, addressing, solving cases that are brought before her or him, we are looking for judges that exercise those responsibilities in a universal way. It's not international, it's not national, it's not local. It will still be the county judge, it will still be the state Supreme Court justice, it will still be the U.S. Supreme Court justice, but the type of decision that we are here expecting judges to give have universal implications by the nature of the parties and by the nature of the problems. And in conclusion, this means that judges, the whole issue of independence and integrity of judges becomes even more important. Because if you expand the responsibilities of the judge, if you expand geographically and make it universal, the bundle of interest that the judge at the end of the day is protecting, the whole issue of independence and integrity becomes necessarily universal as well. So a corrupt judge that is dealing with deforestation, a major deforestation case in the Amazon, but could be anywhere in the world, because this judge is not dealing only with that little piece of land or large piece of land, and the implications can be global. The issue of integrity and independence becomes much more important. And another colleague, I can't remember, I'm very bad with names and faces.
Justice is blind.
Not in my view. You know that we have two goddesses of justice. One is blind, the other one is not. So I take the one that is not blind. But of course we have to follow the Constitution and the laws. A colleague this morning asked the question about how to resist pressure. Because if you're talking about independence and integrity, pressure becomes relevant. And this is, in some countries, something very difficult for judges. A good colleague, and I don't need to, I can mention his name because if you Google, it's there, Lord Robert Carnwath from the UK, from the Supreme Court of the UK, co-organized with the university an event for us, the judges, and he was highly criticized by U.S. Sites for doing something that every judge should do, which is make sure that we learn, that we are not born with all the knowledge that we need. So how can we do this in respect to judges? And as I promised at the beginning, can judges be a witness? That's the title of our event. And if I had never thought about it, because nobody ever posed this question to me as a judge. And thinking about it, I am inclined to believe that judges are naturally and ordinarily a witness of the truth. The problem is that the truth in judicial adjudication many times is not the real truth. We are by law sometimes in many legal systems directed to regard a half-truth or a no-truth as a truth. But in other countries, for example, India, Pakistan, Sri Lanka, and Bangladesh, they have a different tradition. They call it suo motu jurisdiction. And the judges can not only look for the real truth, but they can also, even the Chief Justice, begin litigation himself or herself. Opens a newspaper. There is this major violation of human rights. Well, begin an investigation. This is unknown in other parts of the world, including Argentina, Brazil, and the United States. So, another colleague this morning spoke about guns for hiring in terms of witness, scientific witness that are brought into the courtroom. And this is probably the most dangerous fact to a judicial system that is interested in truth. Because it's not just because sometimes it's not the truth, but it is because the weaker party, the vulnerable, the poor, cannot afford to hire those that are the possessors, the ones that hold the information that could change entirely the result of a particular case. So I think in conclusion that we judges are a permanent witness in the way we write our opinions, our judgments. We are not just deciding a particular case between A and B. We are in fact giving, we are playing the role of the educator as well, and we can do it if we want to. And it's not outside the legal boundaries of our profession. I guess that's it.
Before I open it up, let me say one word in response. Brazil is a civil law country, and the United States comes out of the Anglo common law tradition. The legal systems in Brazil and the United States are the closest of any two between the common law and civil law tradition at this point. And what Justice Benjamin was saying about the presuppositions of a legal system is it's arresting, because in the United States we refer to this as, through jurisprudential theories of Lon Fuller and others, we have certain characteristics that we assume define a legal dispute. It's supposed to be retrospective. It's supposed to be between the parties alone. The facts are controlled by the parties. The impact of the resolution is confined to the parties alone. We have about 5 of these presuppositions. And that defined the common law as it evolved 1,000 years ago in Britain. And we live in a country of Brown versus Board of Education. We live in a country where these sorts of precepts break down, but they map uncomfortably onto a legal system. Last summer, I was visiting Antonio in Brasilia and staying at his house during the time that he was the presiding judge of a 5-judge court on the simple question whether to remove from office the president of Brazil. So if you think about his presuppositions that it's narrowly controlled by the parties, that it's a simple dispute, and we're just going to take the witnesses, that wasn't the newspaper account of that trial. And Justice Benjamin was on the losing side. He lost 3-2, but he was the presiding judge, which meant he wrote the report of the court. He brought down the government, basically. I mean, that's the effect of the findings of fact, the rendition of the deep corruption inside the government. It's a radical change that's going on in Brazil, and these kinds of judicial findings were a critical part of the process. Now, is it a big step from adjudicating who should be president to adjudicating who is responsible for burning so many hectares of the Amazon rainforest? I don't think so, and I don't think you, at the end of the day, think. You may not have that case in front of you right now, but you wouldn't hesitate a minute if that one came up next, and you haven't in the past. I know that. So the challenge is to the way we've inherited historically our legal institutions, and the kinds of roles that we demand that they play in a number of areas. But climate change is one that, as Antonio said, has certain features of breaking down so many of these barriers, because it's not between parties, it's not confined to jurisdictional limits, and so on. So, questions, comments?
and maybe a comment and then a question. The comment is to your observation that the perpetrator and the victim in environmental or climate change cases are the same. You know?
Not the same, but they tend to be mixed.
That come from the same population. Yeah. And I think that relates a little bit to our discussion this morning about why it is so hard for us to think about climate change as a species-wide issue in which we should cooperate. The way we see in Hollywood movies, you know, so where there's an alien invasion, and we band together as mankind and we solve the problem. And I think part of the problem is that we see the enemy, but the enemy is us. And that is very hard to fight. You know, I think that there's no obvious out-group, you know, that's identifiable that we can sort of fight against. And I think that's why, you know, sort of we don't see the level of cooperation. We break down into in-group, out-groups within our own species and fight each other. You know. Then the question relates to your observation that things have changed in different legal systems, that the atmosphere and climate weren't included, you know, as things to be adjudicated. So my question is, what happened? How did that happen and why?
Well, should we take one more?
Okay, yes, Nancy.
I think it relates. You both talked in a way about how the system of rights and duties don't encompass the kinds of questions that are now coming out and coming before the court when it comes to climate change. And I wanted to know if you could give a good example of where the law has changed through adjudication, perhaps, right? To take on some of these new questions.
Yeah, this has not been discussed. It changed without discussion. It happened, and it just parachuted within the legal system. So legislation began to be passed mentioning climate change, and once you mention climate change in law, it becomes recognized by law. Well, in the case of Pakistan, was not a statutory interpretation, but they do have this tradition of suo motu jurisdiction, and so I would not say that this evolved naturally, as Sam said, through looking back, it's quite interesting, quite remarkable, because you were born in Germany, and we in the world, German legal thought is considered the most sophisticated, and every single development in law that we have in civil law countries has been deeply studied in German legal thought, and has influenced the evolution all over the world. Well, not with climate. This just came through and this morning we spoke about nuclear power, nuclear explosion. It's a nuclear explosion within the legal system. And now nobody discuss that this is part of our legal framework. There is no debate. It's zero. I'm probably the only one that will, because I think it educates us, because it challenged the view that law is very hard to reform, to change. You need revolutions, you need wars, and then the legal system changed, but not in the case of climate. There is one change happening as we speak, and this one is being highly debated. So we can compare those two, which is the legal status of nature. And this is a debate that has been going on in this country since the early 70s, but it was already, in medieval times, especially in canon courts, nature could be a defendant. So there are very famous cases in medieval France in which, in case of pests, in insects, they were defendants, and there was a jury and all that. But in contemporary legal thinking, this was unknown. And in the past 40 years, we have been discussing a lot of tension, debate, very rich debate with ethical considerations and of course legal. And more recently, the courts began delivering. The most recent case is the one from the Supreme Court of Colombia that was just 1 month ago, recognizing illegal statutes to the whole Amazon, the Colombian Amazon. And then constitutional changes, the Constitution of Ecuador and Bolivia recognizing Pachamama. So, and my colleagues in Bolivia now, we had a joint training program. They don't know what to do with Pachamama. How are we, do we need to change the way we decide cases? So here you have climate change, no debate whatsoever on the position in the legal architecture, and on the other on the other side, the very rich debate on the legal status of nature.
Do you want to address that?
Sure. So I was interested to hear you give such a powerful defense of the role of the judge in climate change, because I think in the U.S. probably the biggest obstacle that kind of enterprising legal theories have run up against, whether it is the public nuisance cases or the public trust doctrine cases, has been a queasiness on the part of judges about their role in democracy and whether they can, in blowing off these fusty legal doctrines, reinterpret them in a really powerful way to address climate change, whether they couch it as it presents a political question, whether they couch it as there's a preemption problem. It really is all indexed to this is not something judges should be doing. This is something that legislatures should be doing. I think there's a strong case to be made that, particularly where you're dealing with an issue like climate change that has such significant intergenerational impacts, and also that where we're seeing such a problem dealing with the science and the public debate. One of the most powerful arguments for giving authority to judges, kind of the response to the counter-majoritarian difficulty, is when you have some kind of political pathology, and you need judges to protect minority interests. And you could argue that future generations are not currently represented, so maybe there's an analogy that can be drawn there. And I think you can argue that there's maybe a pathology in our democracy around the science of climate change, that because of the systems we have in a court of law for adjudicating science, maybe there's a particular claim that we shouldn't be as concerned about a democracy deficit if judges wade into this issue in a meaningful way.
I think that part of the issue in the United States is that we came to this in the 1960s effectively, and the 1960s was the end throes of the romance of the New Deal state. And so the response in this country was heavily regulatory, and the 1960s regulatory mentality had difficulty with the common law. They still associated the common law with Lochner and with judicial reaction. They did not look to the common law for its transformative powers, and so the judges were not as freely licensed. I think Antonio was overly modest about the path of the development in Brazil. He was the Attorney General, or the Attorney General in charge of environmental issues for Sao Paulo, for the state of Sao Paulo for many years, and wrote a great deal of legislation that got enacted both at the provincial and at the national level. And one of the interesting things about the legislation, this is a discussion over many years, is that he wrote into the Brazilian law a strong access to the court mechanism for not just state regulators, but for civil society in various forms, not as broad as the American cause of action, class action and so forth that I happen to champion, but nonetheless providing a multiplicity of actors that can come to the courts over these issues necessarily brings the courts in more directly and with less inhibition. So I think that perhaps one of the reasons that there was not much discussion about the role of the judiciary in taking on these cases in Brazil is that the legislation was relatively recent and anticipated some form of access to the courts. And once you have that in place, you don't have as much hesitation. That's my analysis from outside.
So two very brief comments. One on what Katie said about the role of judges. I skipped one item of my presentation on the effectiveness of judicial intervention. And that's the critical part of the presentation. Because we should not expect that the climate change crisis will be solved by judges. So this is one recognition that we have to make. But on the other hand, we should not expect judges to be completely alienated from the climate change debate. Because, as I said, we are the adjudicators of life and death, and you would expect those types of adjudicators to deal with issues that are related to the foundations of life. But we should not think that judges, in order to deal with climate change issues, they need to be activist judges. It's interesting to note that in many countries, the term activist judge does not have the bad connotation that it does in the United States. So I'm always correcting my colleagues and say, no, we are not activist judges. We don't need to be activist judges because the activism is in the legislation and in the Constitution. In many parts of the world, what we are doing is basically, the new constitutions that are there, the Pachamama of Bolivia and Ecuador, but those are only over 100, and Professor Nicholas Robinson studied this, over 100 countries have greened their constitutions in many ways. So this is absolutely remarkable. The judge is not doesn't need to be an activist in order to protect the environment. The activism comes from the legislation. This is very, very different. And my comment in respect to the remarks that Sam made, my presentation, I was not really dealing with Brazil, but in more general terms. I forgot to mention that we now have a Global Judicial Institute on the Environment that was that's now registered in Geneva, having its secretariat in Nairobi with UN Environment, and that's precisely the type of collaboration among us, so we can learn from each other. In our judicial portal, we even will be able to communicate in in a manner that only us
Confidential.
Confidential, because the cases tend to be very, very similar, particularly in respect to climate change mitigation and adaptation.
Yes, Naomi.
Sam, could you explain a bit more? You mentioned the Lochner case. Can you explain how that's related in your view to judges' approach
So
to climate
Lochner
change?
was a synonym for judges using traditional principles to strike down legislative advances. And it was done in the name of the Due Process Clause of the Constitution. So when Felix Frankfurter went to India after World War II to advise them on a new constitution, he said the most important thing you must remember is do not put a due process clause into your constitution. And there is no due process clause in the Indian Constitution. It's the only one in the world that doesn't have a due process. So they read it into it because you can't have a constitutional order without a conception of due process. But that association with judges being the obstacle of progress that comes through legislation is the Brandeisian tradition in the United States. And so it was a big transition in the post-Brown v. Board era, when we started to think that judges, in the name of higher constitutional values, could move the society forward rather than looking backward. That's what it's a code for. I'm sorry, I don't know, there's one more hand. Yes?
Yeah, hi, I'm Marie Gottschalk. I'm a professor of political science at the University of Pennsylvania. And I'm not a climate change person, but my main area is mass incarceration and criminal justice. So I have 2 points I want to ask you about. The first is I question this idea of victim and perpetrator in the courts, because it seems to me, and again, I'm a political scientist, so I want to bring the politics back in here, is that in fact we can't have this, we all are of the species, but the idea that a Pacific Islander and Exxon are equally to blame in the courtroom, that in fact we have, courts are all about mitigating circumstances and degrees of culpability. And so I don't necessarily agree with you about that.
And once democracy comes back and slowly society repossess the flag. Due process should not be seen as just protecting individual rights. Due process should be seen as something that protects equally collective rights, because otherwise collective rights will be seen not as a second-class type of right, but perhaps no class of right. So the same concepts that we associate with due process, oh my goodness, I have a vested interest on deforestation because I own this property, I've been practicing this for ages. Vested interest as a concept should apply to collective rights as well. And that's why, for example, we are developing as we speak the so-called principle of non-regression, which means, and it's not just about individual rights, it's about collective rights. If you have granted society, I should not talk about torture here, but so let's get another example. If you have protected, for example,
Abusive interrogations, let's talk about
waterboarding.
Yeah,
No, let's not change to another example. So if you have protected, let's say, whales against hunting, you cannot suddenly, without compensation for the survival of that species, get rid of that protection. It's a collective right there. I mean, it's even more than a collective right because it has to do with other species.
This is why the Brazilian justice system right now is one of the most dynamic in the world. But okay, let's thank.
Little things there.